Just give it another minute. All right, so for the sake of time, I'll start introductions while people are still logging in. I want to thank everyone for joining us today's webinar on how to handle employee discipline and discharge issues. My name is Samantha Poole. I'm the Membership and Business Development Director at the New Hampshire Lodging and Restaurant Association. I'm here with Jim Reedy of Sheehan Finney, Bass and Green, PA, located in Manchester, New Hampshire. Jim's an experienced lawyer, a longtime NHLRA member, and an invaluable resource to our hospitality business owners. Before I turn it over to Jim, though, I'm just going to go through a couple of quick housekeeping. So we would like to be able to answer your questions as they come up. If you could please put your questions in the Q&A below. Jim will answer questions as they arise, but we have a little time at the end, or if we have a little time at the end, we'll go over any questions that maybe we didn't have a chance to answer during the presentation. This will be recorded, so if you would like the recorded copy, we'll be sending this out after the webinar is over. It'll also be on our webinars page of our website, along with a lot of other webinars that Jim, some of his counterparts, and other various allied members of ours have done with us. So if you're looking for educational resources, I highly suggest checking out our webinar section. And from there, I'm going to turn it over to Jim. Jim, thank you again so much for joining us today.
Gosh, my pleasure. And welcome, everyone. Good morning. Happy Tuesday morning. Every day we get a bit more daylight here in the frozen Northeast, and that's a good thing. Happy to talk with you today about a difficult discussion that you might have with employees. That's discipline and discharge issues. And, I don't know a person that in business that hasn't had to have that discussion. Sometimes it's easier than not. It's never easy, but it's a question of easier. I think the thing I'd also like to say is that the law has changed a lot. I've been practicing now 35 years, and in that period of time, there's been an enormous change in the law and our culture. And where the stakes are now higher with missteps for discipline and discharge. And that's what we're going to talk about. We're also going to talk about the fact that obviously you invest a great deal of time and money into hiring staff. And, we're in a time of wage inflation, low job participation numbers, low unemployment. So when you find that employee, maybe it's not the ideal employee, but what if you found that ideal employee and you want to retain that person? There's a lot that goes into that. But then what if it's the person that's not necessarily ideal and you think you're going to try it out, and no matter what you do, it doesn't work out, whether it's attendance or misconduct or just poor performance, and whatever the issue is, ultimately you get to the decision is we're going to cut our losses. This just didn't work out. It's our Mac Jones experiment, that it was a draft pick. We tried, we've tried a couple of different ways, but it's just not going to work out. We want to talk about some of the issues involved, that legal issues and practical legal guidance as to how to handle that. And as Samantha said, I'm happy to answer questions throughout anytime. The benefit of having done this for a long time is I've seen just about every possible scenario at least once, and perhaps many times. That being said, every individual is different, every situation is different, and the risk can vary depending upon the legal issues, the judge or the agency involved, and so on. So let's get to it. This program takes about 35, 45 minutes, depending upon questions and how quickly I speak. One thing I do want to say is that I was sharing with Samantha, one of those many people that got one of these viruses that's floating around a couple of weeks ago, and that's why we had to postpone the last time we we're going to do this on the 13th. And just when I thought it was clear, I got the rebound. So I've got this sort of upper respiratory thing. So I'm not a smoker. I'm not a jazz singer. It's just, this is my gravelly voice, and I've got my coffee and my Yeti here. So just my apologies in advance. So how to handle these things and things to consider. So if things go as planned, or just in case they don't, and you have to defend a claim later. Stating the obvious, this is not your parents' or your grandparents' workplace, because your parents and grandparents, whenever they had difficulties in the workplace, they didn't call the Department of Labor. They didn't ask for their personnel file. They didn't call a lawyer, and they didn't drop a dime to an agency and so on. They accepted it and they moved on, as difficult as the situation may be. But that's not the way it is anymore. One, because of the changes in the law, and the other is the changes in our culture. And certainly things have not been the same since 2020. And in hospitality, you folks all know this, how difficult that was, whether you were able to stay open, whether you had to convert to takeaway, takeout, or you had to mask up, you had to reduce your census, your density in the workplace, and so on. But what's really changed too is that whether we're talking about remote work or just the sensitivities in the workplace, it seems like we have more volatility and more intolerance by employees. And, I spend my days talking with clients, and, when they go through the issue of disciplining an employee and whether or not the employee accepts responsibility for his or her own actions, whether it's attendance, performance, or misconduct. And again, the defense that, well, we've always done it that way. I'm concluding a big matter right now with the New Hampshire Department of Labor, with a large employer, one of your members, and they've basically done everything right. And there's some minor variations, or at least what the Department of Labor thought were variations in the law, and it doesn't necessarily cut it, at least as far as the Department of Labor is concerned. And again, because we've done it that way, it may not cut it with your employees, because they're less tolerant of the way things are in the workplace, because they've got more options, mobility, and also resources if they decide to potentially file a claim. So between the explosion of, and like I said, I've been practicing a long time, which I know you find hard to believe because you think, oh my gosh, he is so young. But the reality is, since 1990, most of the laws that we deal with now did not exist before 1990. The Americans with Disabilities Act, the Family Medical Leave Act, USERRA, which is Uniform Services Employment Reemployment Act, the WARN Act, HIPAA, and on and on and on, the Affordable Care Act, and so on. None of those things existed before 1990. So we've seen an explosion in workplace laws, and we actually saw an explosion during COVID. When you think that employers would get a bit of a break on the state and federal level, we saw an increase in laws and regulations. In addition to that, you've got economic pressures and difficulties with recruitment and retention, which I managed from the outset. And you've got managers and supervisors who hold the keys to your success or potentially disaster. I sometimes describe managers and supervisors as your eyes and ears, but potentially your Achilles heel. And we'll talk about that too. That's because they've got a dual role, and it's training, encouraging, motivating, and they also are responsible for evaluating and providing critical assessments as needed. And when I say critical assessments, or I mean corrective actions, and that's not easy for most people. In fact, where some managers and supervisors fall down is, I know she's not showing up and doing the job as required. I know he's had problems getting along with others and for following instructions and so on. But, I'm going to stress the positive to motivate him or her. That's not necessarily a bad thing, but if that is a substitute for the true report card for how things are going, then you may have a problem. And what is that? Well, down the road, when you go to ultimately terminate the person, they'll say, what are you talking about? I never heard a discouraging word. So what's going on? So I think it's in the importance of critical assessments or corrective actions, and when it's necessary, not being overbearing, but being accurate and being fair, how to do that. Again, they're the people, managers and supervisors, who interact with your staff daily. And, an example I can give you of a bad example is this McDonald's franchise in New Hampshire and Vermont, where managers and supervisors were just a few years away from the youth that they were hiring, but there were issues about inappropriate conduct and comments by the managers and supervisors. So the people that were supposed to interact with, train, and supervise and correct behavior were sometimes the people they're either turning a blind eye towards or potentially making the situation worse. And so when there's employees fall short and the expectations or violate company policies, that the manager and supervisor are the one to call that out, hopefully document it, and also hopefully speak to the individual involved. And we can talk about how it's documented and what the employee sees or hears, but a timely, fair, and reasonable assessment of the person's performance is always the way to go. In other words, not being overly harsh, not being not sugarcoating, but being straight. And a lot of what I'm going to say, obviously, throughout this entire program is common sense. But Samantha and I were talking about this before we started, and she made a great comment, which could be a great bumper sticker, which is common sense is not as common anymore. And that's because we often second guess ourselves because of the threat of lawsuits, the threat of a difficult employee or the employee's family member, and so on and so on. So as we go through this, I mean, again, a lot of this stuff is going to be, we understood that's the way it is. And I'm here to reinforce that, but we can also answer questions as we go through this. So some general advice for tips and supervisors through these difficult discussions. First of all, know the rules. If you're going to enforce the rules, know the rules and make sure that the employee knows these too. And that could be through onboarding, that could be through a handbook, but it's important, even if you've got a handbook, most people don't read the handbook. So really through onboarding and through discussions and through training, emphasizing what the rules are and being consistent in that regard, clearly communicating what the standards are, but being consistent. Because if you vary from what the handbook says, then you've effectively negated the policy or procedure in the handbook. Be measured and appropriate. I just mentioned that. Every situation is different, but be consistent, but be measured and appropriate, and involve HR or upper management sooner than later. You shouldn't go this alone. In other words, get a reality check. You may be emotionally connected as a supervisor or manager. Involve someone else who's a little bit more dispassionate and a little bit removed from the situation. So again, to enforce the rules, you need to know the rules and they need to be publicized. Does the law require that you publicize a handbook? No, but if you're going to have your rules posted in your break room, if you're going to have, if you have job descriptions, which the law will give deference to, where you identify the essential functions of, have that be written. If you have a standalone policy or memo, make sure the employee knows about that. And if you need them to follow directions or abide by the rules, those should be known. And it's kind of silly to say that, but it's, again, you don't want to be that kid who plays Monopoly, who keeps the cover of the game set to him or herself with all the rules. You want to make sure that everyone understands the rules from the get-go. And again, because I said so, it's an antiquated term. Parents don't use it as much anymore. And certainly in the workplace, it doesn't work as much. It really should be based in policy, procedure, common sense, posted rule, posted procedure, and so on. This is how we do things, and this is why we do things. And it shouldn't be just so authoritarian because I said so, because you'll lose the respect of the subordinates, and also it may vary from the written word. Do you need to document things? This question comes up all the time with employers and managers because you don't want to spend your day, detailing and writing things down, sneaking behind, partitions and spying on your employees and so on. But yeah, I mean, think if you went to Catholic school, you were familiar with the term, the permanent record, but the personnel file is effectively that, which is the milestones in the person's employment, from the beginning, from the application and hiring documents through the end of that relationship. And it will be evaluations, but also you don't have to wait for an annual evaluation. You can basically say, this happened and it's a good thing, or this happened and it needs correction. But documenting those noteworthy instances or patterns of unsatisfactory or significant misconduct. So you can do the pluses and the minuses, or perhaps both, but they should be accurate and timely. And just keep it simple. Those notes should be developed and not later. you go to hire somebody in, say, February, like we are now, and in December, you've decided to fire the person. And then it's like, I'm going to write down all the things that happened since February, and I'll do it in December, the day before I fire the person. Probably not a good idea. You want a contemporaneous note. So as that situation progresses, again, pluses and minuses, you're writing accurately at the time. And it's not a lot. It's the things that are truly noteworthy. And again, don't go overboard. Don't spend your days watching employees and waiting for them to make mistakes and writing stuff down. Again, you're going to demoralize your workforce. And also, that's an efficient use of your time as a manager or supervisor. And yes, just keep to the facts, the important things, meaning attendance issues, poor performance, misconduct. And like I said, it's the other side as well. The positive things too, that perhaps you want to make note of, that so-and-so went above and beyond and assisted a client or customer or coworker with something, and they're truly appreciated. But again, being measured and not making it overly positive when it's not necessary and overly negative when that's not necessary either. Again, that's why you want to be measured in your response. You spend a lot of time through that process that we mentioned before, and you want, if you can, keep it simple correction to get the person back on track. But there are times when it's certainly necessary, saying this is just not working out. There was a fellow who was a general manager of a ski area here in New Hampshire, and he had this great expression, which was when he terminated people, he said, "I encourage you to find your happiness elsewhere." Sometimes that's just the way it is. Not everybody is meant to work in your workplace. By skills, by fit, and it just may not work out. Not getting along with coworkers, not getting along with customers, clients, guests, whatever the issue is, or just simply not following instructions, or just doesn't have the right skill set and experience. Whatever it is, make the decision. So things not to do when firing an employee. Here's some common pitfalls to avoid. And yes, unfortunately, I've had to deal with all these, and many of you have had to deal with these as well. This is true throughout life. Don't fire an employee after a heated argument or major dispute. And why do I say throughout life? Obviously, things that we say in our personal lives in anger and frustration. And I moved here from Massachusetts, and I learned long ago not to flip anybody off, because especially in a state like ours, you don't know who has what weapon they have in their car, but also what good does that do? So I think that we might regret when you say things out of raw emotion or anger, or a heated argument or major dispute. Sometimes you'll regret that. And oftentimes, unless it requires it, the best time to raise it is in a performance evaluation at the time, or within a reasonable period of time after you've cooled off. Now, that doesn't necessarily mean that if you've got a situation that needs immediate attention, that you don't address it. You don't say, you know what, you've stolen from us. It's now February. In your evaluation in June, we're going to raise that issue. Not at all, of course. But this is what I said earlier. I think you also want to, if you're really invested in the situation, you want to talk to somebody else in management to get their perspective as well, as you cool down and then have a measured and appropriate response. That doesn't mean if something requires immediate action and a stern response that you're not doing that, but you're doing it when not out of raw emotion. Don't delegate the task of informing an employee of termination. If it's your job, you're doing that, and because you're the one dealing with either the misconduct or the poor performance, and you're the one most familiar with the work environment, the policy, and so on. The other thing is, should you have a witness with you, it's always a good idea, especially these days. So you and someone in human resources or someone else in management, another supervisor, and so on. Not a coworker, but another supervisor or manager with you. And never, ever inform the employee of termination by letter only, unless that's the only way you can get in touch with them. Meaning they're off premises, they've stolen from you, they've disappeared, they're a no-show, and you have no other way of getting in touch with them. But these days, there are more ways to get in touch. My preference is when you're going to terminate someone, you're doing it in person, face-to-face. And it's not easy, but it should be done that way. But never email, text, tweet, or send a message to an employee via Facebook or Instagram, or to inform him or her of their termination, unless that is the only way you can contact the person. Now, you may call them if they can't otherwise get in touch with them, but, and then you can follow up with something in writing for sure. But, emailing, texting, tweeting, or messaging somehow is not the best way to inform someone. That's because, again, people may feel insulted by that, what may be an impersonal response. So that's something, again, you might follow up in writing, but if you can, face to face. And when you're doing that face to face, don't insult or belittle the person. Just stick to the reason for separation. You know, whether it's unsatisfactory performance or misconduct. And don't characterize the reasons for that, like the person is lazy or lacks motivation or lacks intelligence and so on. Avoid, to the extent you can, the employee's personal problems. Now, that being said, if the person's like, look, I know you've told everybody you're going through a divorce, we understand, but you still have to show up. I understand that you've had these problems with alcohol or drug abuse, and we've tried to assist you and offer you resources and so on, but this is the job. I understand that you have had a difficult relationship with so and so, or you may have had past trauma. We're not psychiatrists, we're not psychologists, we're not counselors. You want to avoid those situations if at all possible. It may have had an influence on the workplace, but what matters is what impact did it have on the workplace, and not necessarily the genesis of their personal problems. And certainly don't attempt to dissuade the person, or persuade the person rather, that termination is the appropriate step. If you try too hard, it's going to be overkill. I actually have had a situation where a person was being terminated and the person firing the employee said, "I envy you." And the person's like, "What?" "Yeah, I envy you." The person was being fired in May and said, "I would love to have the time off just to relax in the summertime. I envy you." Well, that's going to be insulting to the person who's being terminated, because, of course, most employees live up to their income level and they've got bills to pay, and they're being told you're being fired, and then being told somehow you're lucky to be fired could be deemed to be overkill and insult the person. That could result in hard feelings that later result in a claim of some sort. I didn't mention the sex harassment before. I didn't mention the fact that you've shorted me on my paycheck with regard to tips or incentive pay. I didn't mention the abuse I was suffering, and I was denied overtime or encouraged not to use overtime. But now I'm going to. Or the comments you made with regard to my race, my gender identity, my national origin, my religion. You know what? Now those are going to be an issue, because it's going to be basically a revenge tour. And don't deny the person the opportunity to speak. And what do I mean by that? That means that you're going to outline you're in charge. It's your workplace. And you're going to outline the reason why we're meeting here today is that we've come to the decision that, either based on this one incident or based upon a trajectory that's unsatisfactory, this is not going to work out, and we've decided to terminate your employment effective X date. And it's usually that same day. I'm not a big fan of saying, we're firing you now, but we'd like you to stay on for 3 or 4 more weeks as we transition. Sometimes that works, but oftentimes I compare that to, I'm divorcing you, but we're allowing you to stay in the house. And, sure, you can date others, just be discreet, but I'll allow you to stay in the house. The tether is broken. So if at all possible, when you terminate that same day, that same moment. And it could also avoid situations where you may have data breach or theft or other issues with that person who stays on after been notified that they don't have a long-term employment relationship going forward. So allowing the person to speak, sometimes they can alert you to things that you otherwise didn't know. Like, yeah, all right, I understand, but let you, now that you are letting me go, and I'll maybe accept responsibility for my own actions. Let me tell you about so-and-so. Let me tell you about whether it's my manager or a coworker. Let me tell you about a customer, a guest, and client, and so on. Things you otherwise might not know. But also could say, you know what, that's fine. I accept responsibility. Or, you know what, I don't think it was my fault because of. So you allow them to speak. It's cathartic. It's a sense of fairness. But you also might learn something that you otherwise might not know. Now, do you lose control? Absolutely not. But allowing the person to say a little bit of something and not just simply saying, don't speak, I'm terminating you, say nothing, just go. Again, you're not going to lose control. Don't let the person rant and rave. You can shut it down. But I think if you give the person an opportunity, at least you have that pregnant pause, you deliver the message, and then before you go on to what's happening post-employment, meaning final payment of wages and so on, the person may say something. That may or may not be helpful, but again, it's a basic sense of fairness. Don't rule out compromise. Now, this rarely happens when you've decided to terminate and yet you decide to change your mind. Why is that? It may happen. It's rare when suddenly you find out, wait a minute, we may have made a mistake here, or we need to find out more. Well, in that case, you might be still sending the person home and checking on some things, but I wouldn't necessarily say, no, we've made our mind up, that's it. Sometimes there might be an opportunity to pause before you actually pull the trigger and terminate. Let's look back at some of the underlying issues that should be addressed first before you've gotten to the ultimate termination decision. These are difficult or different types of workplace problems and how to address those. Is this an absolute no? It's based upon years of experience, but also you may have had these exact same instances, and let's talk about those. How about sex harassment or discrimination? You know that in New Hampshire, sex harassment discrimination continues to be the #1 type of discrimination filed in the workplace. That's because throughout the country, #2, and I'll explain what #1 is throughout the country. #2 is race and national origin discrimination. #3 is sex harassment throughout the country. Why is it #1 in New Hampshire? Because we don't have a racially or ethnically diverse workforce. That's changing. But sex harassment discrimination, #1 in New Hampshire. Now, really #1 in New Hampshire and in the US is retaliation, which I'll talk about later, which is a person complains about conduct associated with them or with regard to someone else, they participate in an investigation and something bad happens to them as a result of that complaint or participation. But sex harassment or discrimination, and we all know the rules. You've done the training, you've got a policy. This is no longer Mad Men, someone chasing a man, chasing a woman around a desk with a martini in one hand and a cigarette in the other. It's changed a lot. The workplace has changed a lot, and the things we say and do have changed a lot. And oftentimes, in fact, almost exclusively, that is for the better. Still, it happens. So how to avoid these situations? And I know that Andrea Chatfield last month talked about this in her program, which was managing sex harassment in this sort of modern workplace. One is having a policy to develop, publish, and promote an anti-discrimination policy. And that one is many state laws, Massachusetts being one, California, New York, and others require that. Even though it's not required under New Hampshire law, should you have it? Absolutely. Under federal law, which applies to you folks, you've got 15 or more employees, you need to have a policy like that because it presents, one, it outlines what you will not tolerate or what you prohibit in the workplace. And further, it also talks about your complaint procedure. But it's also a very solid defense in the event that someone says after termination, well, I suffered this or that. It's like, wait a minute, we had a policy. You never brought it to our attention, never gave us an opportunity to address the situation. That is a good defense in these cases. So one, having a policy, and of course, as I said at the outset, posting it, put it in your handbook, training your managers so everybody's on the same page and the employees know about it as well. And the complaint procedures. The federal government talks about this and said that you should have not just one place to bring a complaint, but at least two. Why is that? Because if one of the people that you're going to complain to is someone who's the bad actor or someone who is inattentive, so you've got an option as an employee where to go, a second source to go. And if you're more comfortable talking to a female or a male or whomever, that is available to you as well. And then in response to requests, that management HR promptly responds to the complaints in the law says a prompt and appropriate fashion, timely and fair investigation. And then whatever the investigation is, pardon me, that you conclude it and you make a decision. And then whole notion of he said, she said is pretty antiquated, because for those of you who have had to investigate matters like this before, for those of you who are parents, for those of you who have walked this planet, you can basically discern one story that's more believable than another's. It makes more sense based on chronology, history, circumstances. And so you make a decision. And then you inform those involved of your decision and the next steps in the process. You document your actions. And again, in that bullet point 7, you take steps to avoid retaliation. So for the bad actor, that he or she remains in the workplace, that you say, look, you're not to retaliate against the individual. And you talk to the victim or victims in the case, and you say, if anything more happens in this regard, come to us promptly and we'll address it. And that's a good way to do it. And of course, you're going to monitor it too. So you're not relying solely on the victim to come forward. You're also keeping an eye on that tenuous relationship. Employee theft. I'm sure you've had to deal with this before, whether it's shrink or it's actual theft and other types of related misconduct. So what do? Well, to avoid the risk and problems in this area, one, you confirm the facts, not just suspicions, but you actually do some level of investigation. Do you do that? You might. You involve law enforcement? You might. Do you get a private investigator? Perhaps. But oftentimes it starts with you and your finance people checking inventory, checking cash registers, checking records and the like. And computer records and the like. HR and management coordinate an investigation of the matter, and they try to narrow down to determine who might be responsible. It may be crystal clear, or maybe several people. It may be minor theft that goes on for a period of time. I will tell you, in law school, I had a professor once who said, people often steal to cover up earlier theft. It's usually not a one-off. So that's typically what you'll find. You might find tip of the iceberg, and you might have to go and dig and find more. You give the suspect, again, an opportunity to explain or respond in case your investigation may have been flawed somehow. But again, you might find out more in that regard about others who might be involved. There's never an excuse for theft, by the way. Of course, we all know that. So, but you might find out more that would lead to even a broader investigation. Or you may be turning this over again to law enforcement if it's that serious. The person responsible for the discipline discharge gives the person the reason for it. You're not going to say we're laying you off. You're not going to say that we don't think it's a good fit. We don't say we're reorganizing. If the person stole from you or was responsible for covering up a theft, that's the reason. And you document the reasons and so on. And by the way, yes, law enforcement may be involved, but if it's that level of misconduct, the epilogue to that would be the person applies for unemployment benefits, and that would be a disqualifier. Disqualifier for unemployment benefits, there are two. One is, well, there are three. I haven't worked there long enough. I haven't worked at least 5 weeks. The second is I quit voluntarily. And the third is I was discharged from misconduct associated with my work, which I know of a policy, I know of a practice, and I violated that. And I knew that by violating it, I could be terminated. Absenteeism and tardiness. Woody Allen said that 80% of life is just showing up. I have a judge in federal court here in New Hampshire who says the same thing, assuming that regular and predictable attendance are essential functions of every job. One of my daughters, her first job while she was in college, her senior year, she complained to me at one point. She said, "Dad, I am exhausted." She said, "I've worked 70 hours. I said, "Holy cow, honey, 70 hours in a week?" She goes, "No, 2. And there was a different sense of a work week and what was involved. Sometimes you have to remind employees that, no, our start time is this hour, and you're to show up, before our start time. Not much more, because you may have a wage and hour issue, but it's say within the nearest quarter hour to your start time. And you end at this point. You don't leave when you decide to leave. We have a set period of time for purposes of work. So showing up late, not showing up at all, and addressing those situations. What are we talking about there? Again, you've got a policy for attendance. You've got a policy for perhaps sick leave. or disability leave. If you're covered by the FMLA, meaning you got 50 or more employees, you've got that, or other types of paid family leave now under New Hampshire law. But the bottom line is, as long as you're clear, these are our expectations, and it's clear. You know, you don't have a situation where nobody ever told me that you had to show up, that you had to show up on time, that you had to call out within a reasonable time if I'm not showing up, that you couldn't go basically absent for days at a time without letting us know. No, you've got a call out procedure, you've got paid leave perhaps, or unpaid leave situations, but the set hours, the days of work, the hours of work, it's clear what they're supposed to do. Again, you're involving HR and other members of management to review the matter and determine next steps. Meaning, is there a good reason why the person was late? What have we done before? How harsh do we want to be? How strict do we want to be? If we're not strict, are we going to be setting a precedent where others might show up late or leave early or not show up at all? Again, you're ascertaining the reasons for this and whether that is the absence or the tardiness is forgivable. But even if it's forgivable, you're going to write that down. You're going to document the reasons. You're going to, with the employee, you're going to review the leave and extended leave policies if they apply and determine if the person's eligible for those benefits. But what that person, the employee, needs to do to apply for those or to be eligible for those. And that may be a doctor's note, that may be more, but you're going to outline that. And again, regular and predictable attendance is an essential function of every job, with certain noted exceptions. If there's an illness or injury that arises out of work or is exacerbated by work, you might have a workers' comp issue. And you may have light duty that arises from that, or a period of time where the person is not working. So you're notifying your workers' comp carrier in a timely fashion, if that is appropriate. HR will designate FMLA leave if that is appropriate. And again, in your workplaces, probably not many of you have 50 or more employees for purposes of qualifying, and the employee has to have worked for you for a year, and in that year period, at least 1,250 hours, which is basically a part-time schedule to be eligible for FMLA. Even then, it has to be, the employee has to have a serious health condition or caring for a family member with a serious health condition. And even then, there are procedures on block time, intermittent time, reduced schedule time, and so on. But HR familiar with that if it applies, following those procedures. And they may require it with those procedures to get some sort of medical certification from a healthcare provider and the reason for the leave. And again, monitoring that to make sure that the leave is in accord with those certifications. And if, as appropriate, if the person's just not showing up on time, it's chronically absent and or tardy, you're going to have a seasonable or timely discipline, and deciding on whether it's a warning, a written warning, a suspension, or termination, or however you decide to do it. And you're not locked into one thing or another. You can decide what to do. Just be, as I said at the outset, being reasonably consistent. If you're going to basically say the person doesn't seem well, or they're having difficulties performing the job and so on, that may be an issue. Well, then you're going to perhaps have the person submit to a fitness for duty exam, either through their physician or through yours, and you might pay for it at that point. But you're not doing that in all instances. That really is, if it is an issue, the person not showing up, or they're tardy and they're blaming it on a physical or mental health issue. And again, you're documenting the reason for the attendance issues and your responding actions. Here's a good one: insubordination or bad attitude or poor performance. You know, sort of, this is going to sound like an old man saying this, but somehow the barriers have been broken down between and the informality in the workplace now, where you might have an employee expressing not only a bad attitude but being insubordinate in the workplace. And that doesn't mean we have to have referring to us formally as or there are formal lines necessarily between management and the employees. However, you can have an expectation of professional conduct in the workplace, and but also bad attitude and poor performance you don't have to accept. So again, you're going to outline what your expectations are, your work rules, your performance standards, your expectations. Not only dealing with coworkers, dealing with management, but also dealing with your clients, your customers, your guests, and so on. And again, as always, promptly responding to unsatisfactory conduct or performance, honestly, directly and without delay. So don't tolerate it. If it's a minor issue, again, the person may not be feeling well. The person may have had a bad day. Everyone has a bad attitude or a bad day from here to there. It may be season-affected disorder in the dark months that we had. It may be they dealt with something outside the workplace. It may be that they're a Patriots fan and not happy with how things have gone. Whatever the issue is, deal with it and say, hey, look, I noticed this. You seem to be off today. I heard your exchange with, or someone complained about your conduct. Let's get it back on track. Now that's if you need to, but if it's really bad, you say, let's get it back on track. You might have to have a more serious response. Again, you're involving HR, another member of management, so you can consistently apply your work rules, and you're going to document again the reason for this insubordination, this bad conduct, this bad performance. Workplace violence. The leading cause of workplace violence is not mental illness. It is not alcohol or drug abuse in the workplace, believe it or not. What is it? And it's not a bad boss either. It is oftentimes outside influences. It oftentimes is involving situations of domestic violence or domestic disputes outside the workplace. Now, does that mean you can't have someone who's mentally ill or subject to or suffering from substance abuse disorder? Not at all. But oftentimes it's domestic disputes that spill over into the workplace. And it's something that, sadly, that we need to address. So what does that mean? First of all, you're going to have a policy with regard to weapons in the workplace. And hopefully you basically have a situation where you don't allow weapons of any sort in your workplace. And you consider a workplace violence or in areas of vulnerability, and you do a risk assessment. What does that mean? You should have a plan and visit your office security procedures, not only for lockdown, it's for purposes of locking down the door for keeping somebody out, but also exit, where there's an easy way of egress to get off of and out of the workplace. Create that emergency response policy and evacuation procedure so everyone knows about that. So if it's not a staff member, but it's a guest or a client or a customer, you have a procedure for locking down, alerting 911, alerting police, but also just getting off premises, escape. Escape should be the first instance, and then to the extent you cannot retreat, then the person defending themselves. But in many instances, it is training them on drills for actually making their way out of the property, and with that, hopefully reducing the risk of potential harm. Encouraging employees to provide information about coworkers where there may be threats, whether it's a restraining order that's happened because outside that you otherwise might not know about yet, drug or alcohol issues, domestic disputes. Again, it might be other issues that might be affecting the person, or someone who might be a customer or guest, and having that bring that to your attention so you can respond to it. Zero tolerance policy, of course, for threats or actual violence, responding obviously promptly to these situations and immediately responding with all the appropriate resources and assistance needed for your employees. And that also may involve immediately calling 911 to get assistance. You're disciplining, of course, the offending employees as appropriate, threats or actual violence. And usually that would be a zero tolerance where you're terminating the employee for that. And that is not to be tolerated. And then again, you're going to document what it was and your response and why you responded the way you did. What about quiet quitters? That is something that's come up in recent years, where people that otherwise may have left during COVID have decided not to leave, but they're going to put in the bare minimum. And what do we mean by that? They don't engage, they do the bare minimum, they do nothing more, they skate by, and they cause problems with coworkers. Do you have to tolerate that? No, you do not. Regardless of how thin the labor market is, you do not have to tolerate that, because it can be like the virus I'm suffering from. It just sort of lingers on and affects others. So to avoid the risk of problems, you should identify the underlying problem. Why is the person a quiet quitter? Were they denied a raise or a promotion? Is there something else going on? Is there something unique to that person? Is this something new, or is there a larger issue here where they're demoralized? Is it their supervisor that's causing them to be demoralized? Is it company policies that can perhaps be addressed and remedied? And can it be corrected? Or are you going to accept a C student as satisfactory in performance? it's good enough. Are others impacted by that? And is it effectively going to be a creating toxicity in the workplace? Again, is this a wage or benefit issue that can be perhaps addressed rather? Are these working conditions? Is this a COVID hangover? Or is there a good reason, or is there no good reason for this? But again, identifying it and hopefully correcting it. And how do you address it? You might address it through a workplace survey. It's not a bad idea to ask these questions. You may not always accept them, but or you accept it for now because it's tight to find people. That's the C student thing. Or making an example of 1 or 2 employees to say, look, we're not going to tolerate this skating by, again, or ignoring it for now. I'm not a big fan of that unless it's minor and it's seasonal. Focus on the meaningful changes that you can make and monitor engagement and pivot or make changes as necessary. And hopefully that, based upon either your informal discussions or more formal survey or observations, you decide to make those changes. So some common questions from managers and supervisors. Let's go to those. And here's one. Can I still be friendly with people I supervise? And the little meme here on the card is, let's be clear, we're only friends on Facebook, not in real life. Get it? Can we still be friends on Facebook? I'm not a big fan of supervisors and managers being friends with the people they supervise on social media. And why is that? Because you might find out things as a manager or supervisor. One, it creates more informality. And the other is you might find out things on social media that you don't need to know in the workplace. And that might color or influence your decisions. So I'm not a big fan of that. If I'm the enforcer, I may not be able to build an effective team. So I'm not going to be an enforcer. I'd rather just be the friends, the friendly person that people can otherwise go to. And why don't I just have HR handle this stuff? I'm not a fan of that either. You need to partner with HR. If you are the direct supervisor, if you're the manager, you are the representative of the company and you are to enforce the rules. Does that mean you have to be a jerk? Absolutely not. You can basically be friendly and fair and reasonable, but there is a difference between you as a manager and supervisor and the people you supervise. And you still have to be that representative and the embodiment of the policies and procedures. If these are all at-will employees, can I do whatever I want? Well, the notion of at-will employment comes from English common law, which is, of course, still the law in many states, including New Hampshire. And what is that? It means as an employee, you're free to go at any time you want, with or without reason or notice. And similarly, as a company, you're free to let the person go at any time for any reason or for no reason, with or without advance notice. However, since 1990, there's been an enormous erosion in that flexibility by employers because of the many protections under law. And so can you let someone go for an illegal reason? Discrimination and so on? Absolutely not. And so on. So many protections in place for the employees. They're still at will, but do you have to abide by legal protections? Yes. So you don't have unfettered discretion in that regard. So let's go through some termination decision-making and the process step by step. Here's a checklist that you can follow, a pre-discharge checklist, if you will. Has HR or upper management been consulted? Good idea, because you're not going to go this alone. Other issues to consider. Does this person have a contract? And that's rare, because again, they're probably going to be at-will employees, but if there's a contract, there may be some formality required as a part of the termination. Is the employee in a protected class, meaning things under federal and state discrimination laws, meaning are they over age 40? Are they under age 18? Are they based upon gender identity, based upon sexual orientation, color, national origin, pregnancy, religion, disability, and so on? If so, am I treating that person differently because of that protected class, or is it a more benign or neutral reason? Is the employee on light duty? And if so, there are certain protections, and that typically will come up either with disability law or for workers' comp. Is the employee on a statutory leave, meaning like family medical leave and so on, or pregnancy leave? Has the employee complained about a workplace safety issue? So you might have an OSHA violation. Has the employee complained about harassment or participated in a recent investigation, therefore potentially avoiding retaliation? Or is there a separate reason for this person's misconduct? Meaning they may have complained about it, but then they've been chronically absent, or they've stolen from you, or they've done something that could be a separate reason for discharge. Has the employee been vocal complaining about terms and conditions of employment? And I raise that because of the National Labor Relations Act and the protections even for non-union workplaces, where that person is saying not just about me, but my coworkers with regard to terms and conditions of employment. That is then called protected concerted activity, and something you have to be aware of, because that could be a violation of the National Labor Relations Act. Assuming these issues have been properly addressed, what have you done in other similar circumstances? Now, again, you're not going to treat all circumstances exactly the same, but some degree of consistency, probably not a bad idea. Yes, again, as I said at the outset, document for purposes of, when appropriate, the milestones, the important events, and it's a timely documentation. And when you decide to terminate, how and when you convey that can determine what happens next, meaning your risk. And here's the checklist that I like to follow. Again, HR will guide you through the process, and assuming there is an HR person in your organization, or if you are you're working with others in the organization, HR will provide guidance and assist you with regard to warning, discipline, and termination documents that might be in place before the actual separation, if appropriate. The direct supervisor and HR upper management will conduct this session. Again, you're not asking someone else to do it. You're doing it. If you're a part of the decision-making process, you're a part of that session yourselves. All key events and supporting information are clearly documented, meaning for your purposes as the employer, not necessarily for the employee's purposes, but some of those things in a document created and maintained by the employer pertaining to the employee is a part of that person's personnel file. So with certain noted exceptions. So those things are a part of the file, and oftentimes employees post-discipline or post-termination are asking for a copy of their file. So you want to make sure those ducks are lined up before the termination session. And again, keeping it to just the facts, keeping it as concise as possible. Check and confirm that all policies and procedural hurdles have been covered, meaning if you have progressive discipline or a warning system in place, what you're doing in that regard, but otherwise that you're following your policies and procedures. Make sure that the decision makers all agree, are informed in advance of the termination, so you don't have a situation where someone, like with the Patriots, runs to Robert Kraft as opposed to having dealt with Bill Belichick on a matter. You have a situation where everybody's aware and involved. So meaning upper management, co-owners, and others, that they're aware and they're on board that this is happening. Notify the employee of a time and place in the meeting. What do you have to say? Hey, next Tuesday, I'd like to meet with you about terminating your employment. Certainly not. It can be as simple as, and I would not provide much advance notice. Hey, do you have a minute to talk with me in my office? That's really as much you want to do. You want to avoid a situation where you provided too much advance notice that the person might skip out or fall down and claim workers' comp accident, or somehow deal with changing evidence or talking to other witnesses about a matter before they can terminate it. It is effectively a form of providing very little notice, and maybe perhaps surprise, but I will tell you, in my experience, oftentimes people know, and they can hear the footsteps. They'll know why they're being terminated. So when you say, hey, you have a minute to talk with me in my office, they'll know that they're not going to get a reward or a benefit in that regard, that something bad is about to happen. Asking another person to attend the meeting, as I said, depends on the circumstances, but generally speaking, it's have a witness there, so they can hear what is said and what's done, and they can perhaps document afterwards, because that may be challenged later. That, oh, when I was fired, this is what was said to me. Well, if you have two people representing the company, that second person can say, no, that's not what was said. This is what was said, and so on. Make arrangements so you won't be interrupted. So you're not sitting in an area where other people walking by and poking their head in, or you're not getting phone calls, emails, or uninvited people, again, stopping in and interrupting. And again, it's a way of preserving the person's dignity too, that they're not on display and being fired in front of other people. Take discrete steps to basically change the person's login, security access, keys, access to the building computer, and so on, bank accounts and the like, whatever applies. That's done during the termination session, if at all possible. Have a final paycheck calculated. In New Hampshire, that's within 72 hours of the last day of work. In other states like Massachusetts, it's immediately upon separation. And in that final paycheck, it is for hours worked, for the hourly employee, for the salaried employee. Generally speaking, it's for the entire pay period, if they performed any work in that pay period, with certain noted exceptions. One would be if the person's fired for serious misconduct, or if they started work after the period, or if they've resigned before the end of the period, and so on. But and if you pay your PTO upon separation, that should be a part of it's your policy or practice to pay upon separation. That should be a part of that final paycheck too. Plan in advance how that session's going to go, who's going to attend, and what's going to be said. Not a bad idea. So you're not just winging it. And it doesn't have to be overly formal, but just have a plan. If you're going to have a separation agreement and a release, you're working with your legal counsel on that to make sure that it's a proper agreement and that it's given to the employee and how it's done and drafted. If COBRA applies, meaning you got 20 or more employees and you're going to provide some form of continuation option for health and dental benefits, you're providing that information at the termination session, maybe, but you might be doing that certainly through your third-party administrator afterwards, within the statutory period, that the person knows that they have an option to continue health insurance or conversion of other benefits with private pay. Again, you're allowing the person to say something perhaps during that session without losing control. If the person has any grievance or appeal rights, which generally doesn't apply in most workplaces, but if that does apply to you, you're advising them of that. Are you going to allow the person the opportunity to resign? Sometimes that helps save face. Other times you're giving mixed messages. It's up to you. But ultimately, for purposes of the person did resign, or rather was terminated, and you're reporting that out either through a negotiated separation or otherwise. But you want to keep that record relatively straight. Yeah, you're terminated, but we allowed you to save face until prospective employers that you resign to pursue something else. Don't lose control of the meeting. Stick to the decision and move on from there. Again, you might have a situation where you're allowing the person to talk, and you might have a situation where you pause and you decide to, look, I'll get back to you on this, but those are rare. You allow them to talk briefly, you don't lose control. After the session, you're documenting everything that's been done, what was said, and what the plan is next. Don't promise the employee that he or she will receive unemployment benefits, because that's not your decision. That's the decision of the state. And, options include termination, negotiated separation, lack of work layoff, misconduct, voluntary quit, and so on. And we talked about how someone might be disqualified. But again, you're just going to report in a timely fashion the information to the state and let the state decide. Don't drop the ball. And then what do I mean by that? That means that when you have a situation where the employee tries to call you afterwards and ask either for references or for information about, I left behind my personal property or something else, you're not ignoring that person. Now, you don't let the person hound you and harass you through social media or phone calls or come into your place of work. But if it's really simply a call and responding to requests, by dropping the ball, I mean not responding to the person, and that may cause the person to file a lawsuit or claim because they're insulted or they're frustrated. If you, again, appropriately respond and without being abused, then you may diffuse the situation. Maintain the personnel file. You're going to keep that for 3 years post-separation, and the person may ask for it. And then be careful about what you say to other employees. You want to keep it on a need-to-know basis. So-and-so isn't here anymore. You're going to stick to verifiable statements of fact. And if it's something more involved, we fired so-and-so, you're talking to the victims for his or her bad conduct. And that's something you can do, but keep it to simple, verifiable statements of fact. Again, if severance is offered in exchange for release, you're working with legal counsel on that, and you're working through the requirements of that agreement. And when in doubt, of course, you're talking to other members of senior management, and you might be talking to legal counsel. And then what goes in the personnel file and what is disclosed to the former employee, you're confirming with your legal counsel as to what should be involved in that. What about the termination is documented? Performance or conduct issue, prior warnings, perhaps witness statements, maybe. Although peer evaluations are not a part of the personnel file. An investigation summary, perhaps, but not the actual investigation itself, because that might include peer evaluations, which are not a part of the file. How the termination session went, perhaps, but the any termination separation documents, yes, and any follow-up documents, if any. And again, what do you do with regard to requests? You be careful, you involve upper management as to what should be in the file and what's not. How long do you keep those? Again, generally speaking, it's 3 years, nothing less. What about electronic documents? You're keeping those because under the federal rules of evidence, you have to preserve those documents if there's a threatened or actual claim. And never go it alone. You're coordinating your all of your actions and your responses with HR, upper management. And again, the conclusion here is you spend a lot of time recruiting, training, motivating, retaining talent. You hold the keys to success, but if things don't work out, you've got a guide to respond. I have no question in my experience dealing with Mike Summers and Samantha and others, and also my experience dealing with clients in your space, in the hospitality space, I'm certain you're up to the task and you can handle this. And I'm also certain that you're doing things appropriate. Go again, you're not suspending common sense. You're following these guidelines, and you've done it long before this presentation. But it's an ever-changing workplace, and you should be careful out there because things continue to change and the risks are high. So I hope that was helpful. Samantha, any questions?
Sorry, it doesn't look like we have any questions in the chat right now. I know that we're coming up on the end of our session, so if anyone does have any questions after the fact, please feel free. You could shoot me an email, you could reach out, we can either answer your question or connect you with somebody who has the answer to that question. Oh, we do have one quick question. When a situation arises outside the workplace, how far should our investigation go?
The situation arises outside the workplace, how far should our investigation goes? And this is an answer that I learned early on in law school, and the answer is, it depends. And the answer is depends upon what that situation is. I've heard that the person is involved in an issue of domestic violence. I've heard the person had a DUI. I've heard the person was spent the weekend in jail. I've heard the person has been accused of inappropriate sexual conduct with a minor. I've heard that this person may be a part of a radical fringe group that's doing this or that. It all depends. But whatever it is, if it impacts your workplace, you can certainly respond, and you can ask, you can check resources. You might have to go through the employee, but if it's a public record through criminal records, you can do that without consent of the employee. You can certainly check on social media, but I would double check what you find on social media if it's a public record out there. And you could certainly ask coworkers and or the employee, but it depends upon the circumstances. But if it's outside the workplace that could have an impact on the workplace, you certainly can follow up as appropriate.
Awesome. I think that is it for the questions we have right now.
Well, I hope that's been helpful, and I want to thank you all for taking time. This is for you, for all that you do. And I want to say also especially thank you for the difficulties that you had during the last 3 years with COVID and how you managed to make it through. Yeoman-like effort for sure. My wife and I spent a lot of time in the last 3 years buying a lot of gift cards at restaurants and other places in the hospitality space. We've yet to use any of those, so we certainly will be. But it was a lot, and you've gone through a lot. And again, it's a changing legal landscape, and we appreciate your efforts. We appreciate your perseverance, and thank you for your attention today.
And thank you, Jim, for taking the time out of your day to do this presentation with us. It's incredibly valuable for our members to have these kind of presentations that you and your counterparts put on. And, we really appreciate you taking the time.
My pleasure. Thanks so much, folks. Enjoy the rest of the week.
Thank you.
Bye-bye.